The Committee to Recall Sheriff Jerry Hatcher has created this video series where we break down the 8 counts of the recall for Sheriff Jerry Hatcher and explain the evidence supporting each of these counts. As much as Sheriff Hatcher's divorce is brought up, this is the only count that has any relationship to it. This 6th count that the courts were asked to rule on is that Sheriff Hatcher made false or misleading statements to law enforcement and the courts regarding the number of firearms he needed to surrender pursuant to a court order. On October 5, 2019, Sheriff Hatcher was served a protection order in relation to his divorce, in which he was ordered to turn over all of his guns, both his personal and BCSO guns. On October 7th, he turned over 3 weapons, including his .40 cal service sidearm, to the Kennewick Police Department. On October 8th, he turned over 1 more handgun. On the morning of October 15th, 10 days after the order was given, he told the court that he complied with the order. His estranged wife gave notice to the court that there were still weapons at her home. Shortly after the end of the court hearing, Sheriff Hatcher contacted the Kennewick Police Department and told them that he had more guns at his home, but he wasn't able to comply earlier because he was having carpets installed. When Officer Guerrero went to Sheriff Hatcher's home, he collected an additional 5 guns, and when Officer Guerrero was preparing to leave, Sheriff Hatcher informed him that he had more guns at his home that he shared with his estranged wife in Kennewick. On January 10, 2020, Sheriff Hatcher's estranged wife reported to KPD that she was cleaning out the garage and found additional guns and ammo. On January 13th, 10 more guns were collected by officers from KPD. Included in this list was Sheriff Hatcher's duty rifle and shotgun. This is also when the 14 cases of BCSO ammo were discovered. The issue here is that Sheriff Hatcher did not disclose all of the firearms to law enforcement, made false statements about how many firearms he had, and then lied to the court about having surrendered all of his firearms. Individuals who support Sheriff Hatcher like to say that he complied 110% with the court order and that he couldn't surrender the weapons stored at his estranged wife's house because of the protection order. This is only partially true. While Sheriff Hatcher could not go to his estranged wife's house, he should have told law enforcement about all of the firearms and ammunition stored there, and not just about the 2 department-issued firearms stored there and some practice ammo. He was given another chance to come clean and should have been the one to mention them in court. Instead, he lies to the court and says that he has complied with the order. Only after his estranged wife brings up the weapons in court does he come clean about the other weapons. His excuse about carpet installers preventing him from complying is flimsy at best. Having carpet installers in his home would not have prevented him from telling KPD about the weapons that were stored there. They also would not have prevented him from telling the court about the weapons stored there. The installers also would not have completely barricaded access to any part of the home for 10 days. You know the old saying, where there's a will, there's a way? If he really wanted to comply 110% with the order, he would have found a way to gain access into his home where they were stored and had been honest about all of the guns that he had stored in the garage at his estranged wife's home. Any individual who did what Sheriff Hatcher has done would be facing penalties. A deputy in this situation would have been discharged in addition to any penalties that may be imposed. With the authority that law enforcement officers are given, they are held to a higher standard so they face more severe consequences. For an elected sheriff, this discharge goes by the name of a recall. Remember, a recall is not a criminal trial and doesn't even have to include criminal elements. Violating the oath of office is sufficient grounds for a recall. If this behavior merits a discharge, then it merits a recall. You can find all the supporting documents for this count on our website at www.recallsheriffjerryhatcher.com. This video series was paid for by the Committee to Recall Sheriff Jerry Hatcher. Top contributors are the Washington State Fraternal Order of Police, the Benton County Deputy Sheriff's Guild, and Kathleen Werschke.